Hey, Rick Angel here. They got James Anderson with Anderson Law Firm. And so, Mr. Anderson, could you just tell us a little bit about what you do?
Here we primarily practice estate planning law. We do some real estate transactions and some asset protection work, but primarily we're an estate planning firm.
Okay. So, a common question people have is, trusts. Why would I need one?
Uh, the way I look at it is if you own real estate, if you own a house, I don't care if it's mortgaged or not. If you own a house, you will most likely benefit from having a trust-based estate plan because whatever assets you put into a trust, your house, your retirement plans, your investment accounts, your bank accounts, etc., business interests for that matter, whatever goes into a trust, it passes privately according to the terms of one's trust agreement, and it does not go into probate.
So, I'm going to kind of build off of that. What's probate, and why would somebody want to avoid that?
Probate's the default county level bureaucratic mechanism by which a deceased or an incapacitated person's assets and affairs are handled. If we own an asset that's just in our name, or even if we own it with our spouse, if it's not the right way, and we die, that's going to go into probate. Whenever there is real estate involved, or if there is no real estate, whenever there are other types of assets worth more than $25,000, you can expect probate to be a 1 to 2 year long process. It's public. It's not something that people relish at all, but in particular when they're grieving the loss of a loved one. Um, you know, People talk a lot about wills, but wills are wildly overestimated devices. Wills do two things. One, they allow us to nominate a guardian for our orphaned underage children, if that's a potentiality. The other thing they do is they allow us to better control what happens to assets that go into probate when we die. So if you have little kids, you ought to have a will because we don't need your family to fight over who gets your kids. But that's all you want to use the will for, um, um, because like probate is intrinsically inefficient from a time perspective, from a cost perspective, and it's I'll put it to you this way: a lot of the new business that comes in my door are people who have lost a loved one and they've been slapped across the face with probate, and it's not what they anticipated, it's not what they expected, left a bad taste in their mouth, and uh, their perspective is, something happened. When my time comes, I don't want for my people to have to deal with what I've just dealt with.
It's good. So, yeah, a will,
Hmm.
it's pretty common. People hear about that a lot and say they should have a will. Let's say they do have a will. What's the reason that they would want to consider doing a trust?
For me, the line of demarcation is: do you own a home? I don't care if it's mortgaged or not. Yeah, do you own a home? Do you own real estate? Because when you cross that particular threshold, that's where you're likely to get a positive return on investment for taking the extra effort in setting up the trust and funding the trust with your property. Um, um, there, whenever there is real estate involved in probate, you are guaranteed to have a 8 month creditor noticing period where advertisements run in the newspaper for the benefit of your creditors, and it forces you into a holding pattern. And you may or you're those that come after you may or may not be able to sell your home during the pendency of that creditor noticing process. Um, it might require approval from the probate court judge. It's not ideal. You would want your surviving spouse or your kids or whoever it is to be able to, as seamlessly as possible, settle your affairs privately without that public probate process.
So very correctly, one big difference between a will and a trust is even if you have a will, you're still going to have to go through the probate process.
Absolutely.
And with a trust, you don't. Is that correct?
If the trust is properly funded, if all the assets that you have that need to go into the trust are in fact in the trust, that's not going to go into probate. We can't guarantee to somebody that there's not going to be any probate. We've had, unfortunately, situations where clients have passed on, and it's a situation where the hospital killed them or the nursing home killed them, and the family's angry and they sue. And in those instances, they did have to initiate probate to commence with the lawsuit. But those are the exceptions. Ideally, you get your trust set up. The trust is drafted to take the place of your will, to direct who takes over when, who gets what, how, all that. If there are no extraneous issues and everything that needs to go into the trust is in the trust, it's going to be administered privately.
Another understanding that I have that I think you taught me or told me is that having a trust or having somebody like you is very beneficial. When people pass away, you step in and help in some way.
Yeah. And we've, goodness, 2021 was a rough year around here. We had about 150 clients die between Easter and Thanksgiving. So there was a lot of that went on. I personally am a proponent, I'm a fan of using trust companies to take over at someone's death. If I died on my way home this evening, there's actually a local trust company who would step into my shoes and take over my trust and handle all the post-mortem administrative minutia that would need to be handled. My final tax compliance, bookkeeping, filing the claims paperwork with my life insurance and retirement accounts, and sell my law practice, so whatever else needs to be sold. So my wife doesn't have to do it. It's not because she can't do it; she's not capable of it. No, she's perfectly capable and she's shrewd. I just don't want her to have to do it.
Yeah, that's good. What's the difference between a revocable trust versus a irrevocable trust?
Good question. So irrevocable trusts are really, and they take several different forms, but in general, those appeal to people at opposite ends of the wealth continuum. For people that are particularly wealthy, they can be a tax planning tool. It could be a way for them to start to this year make their $17,000, per donor, per donee, per year gifts to like their kids, their grandkids, to reduce the size of a taxable estate, while also keeping parameters on how those gifts are given. As opposed to just trying to stroke a 5-year-old grandchild a check for $17,000. That's not going to work, right? So put it into a trust for them. For people with more modest estates, that typically represents a Medicaid planning tool. Someone might set up a trust for the benefit of their descendants and maybe move a remainder interest in their home, other strategic assets into that trust to start to get things out of their name to get in front of that 5-year Medicaid look-back period.
Okay. So revocable versus irrevocable. It sounds to me like, in layman's terms, like one you can take away or do away with, another one you can't. Is that
Yeah,
correct?
yeah,
That
yeah.
simple?
Well, being a lawyer, I can't make it that simple, but yeah, I mean, an irrevocable trust by nature is a way of you giving a gift to somebody else. It's just attaching strings to that gift. Irrevocable trusts can be amended through court action or by way of a trust protector or some a technique that we refer to as trust decanting. But that's not an easy thing. Revocable trusts, and I tell people, in a given period of time, if I draft 100 trust agreements, 95 are going to be revocable trusts and 5 will be irrevocable trusts. Revocable trusts are the right thing for most of us.
Okay.
Revocable trusts, yeah, your kid makes you mad. You can amend the trust. You can write them out of it. They get back in your good graces. You can amend it again, put them back in there. It's whatever's in that revocable trust, you still own. You're the only trustee and only beneficiary of your trust for as long as you're alive and not incapacitated. You can do what you want to do. You're free to change your mind. It does not encumber you in any way. A revocable trust, that's a different matter.
Okay.
So,
and how does trust also provide some type of liability protection for like kids or something that, for example, if they get married down the road and then they get divorced, is there some type of protection?
Really good question, and the answer depends on how the trust is designed.
Okay.
So, for starters, it's important to point out that a revocable trust for us while we're alive is not an asset protection tool. That the stuff that's in there is still considered to be ours. Mm-hmm. The trust is merely a stand-in for ourselves to take the place of our wills and the underlying probate process. Okay. The trust itself can be designed in such a way that when you die, you just blindly stroke a check to your kids, and there is no protection there. That's not the way I like to operate. What I prefer to do in almost any instance is draft the trust so that, let's say somebody has 2 kids and they like their 2 kids and they're going to give their stuff to their 2 kids equally. That the mother trust, the revocable trust, at the client's death, that then becomes irrevocable. It spawns 2 baby trusts, one for each child. Each child's inheritance goes into his or her separate trust. As long as that inheritance is maintained within that trust, it is not touching those children. It's not commingled with them, and we ought not have to worry about them getting divorced or sued or bankrupted or nursing homed out of that inheritance. Okay. If it's administered properly. And the cherry on top is you get to preordain where this stuff goes when a child dies. Whatever's left over, as much as a client might like their in-laws, they love their grandbabies more. Yeah. And they want to keep things moving on down those bloodlines.
Yeah. So I've heard a little bit about life estates. What is a life estate? How's that different from a trust?
If you're going to Venn diagram this stuff, there's some overlapping circles there. Life estates are used for 2 primary purposes. One is to keep a parcel of real estate out of probate. The other is for Medicaid planning purposes. So let's say you have going back to this kind of modest estate paradigm. Let's say you have a couple that have their marital home. That's where they've lived for the past 30, 40, 50 years. It's paid off. That's their primary asset. They have very little in the way of retirement savings. They're living off of Social Security maybe a pension, something like that. And they know that if anybody has to go into a nursing home, that's going to eat up what little cash reserves that they have in no time flat. And they are concerned about having to get on Medicaid, having the state file an estate recovery lien on their property after they die, and gobbling up the equity in the home that they've invested in for all these years, which is the main asset they have to leave to their kids. Well, so mechanically, the way a life estate works is, let's say you got this couple, and they have 2 kids. They want the kids to get in a house. They'll sign a life estate deed where they convey what we call a remainder interest in the property to their children. The couple, they maintain a life estate, which means that as long as one of them is alive, the property's theirs. It still qualifies as their residence for property tax purposes, homestead, all that. But upon the passing of the last of them, that life estate, poof, that evaporates. The children's remainder interest vests, and the property becomes theirs by operation of law. It does not go into probate. The other thing that the life estate does is from the moment that they sign that deed, that gets the clock ticking on that 5-year Medicaid look-back period. And so if any point 5 years thereafter, if they did have to go into a nursing home and they did run out of money and they did have to get on Medicaid, Medicaid's not looking at the house. Okay. Life estates have their place, but they are crude, simple tools to use. The biggest weakness, in my opinion, is you got to assume that the people that are supposed to survive you do in fact survive you. And I've had to have too many conversations in this room with someone who had done a life estate for the benefit of a child where that child died on them. And then that remainder interest, that goes into probate for that child. Maybe it's going to their spouse. Maybe it's going to their spouse and their kids. Who knows where it's going? Right. And so I'm not a huge fan of life estates because of that. I mean that's a very difficult, very unpleasant conversation to have with a parent who's grieving the loss of a child.
Thank you.
Mm-hmm.